Imagine pouring millions into building your dream luxury home, only for the project to stall, a contractor to claim hundreds of thousands more, and a high court judge to say, hold on, this isn't as clear-cut as it seems.
Yeah, that's exactly where we're going today.
We're diving into a fascinating high court judgment from England.
It involves a building contractor, RBH, Building Contractors Ltd., and a couple, Mr. and Mrs. James, who were, well, building this really substantial property in Nearth Devon.
Our mission today is to pull apart this intricate legal battle. It's not just about the money, though there's a lot of that involved.
Oh, definitely. But it's also about what legally counts as a home,
Yeah.
and the really precise wording needed in legal notices.
And maybe the most surprising bit, whether a judge can actually overrule a previous decision, an adjudicator's decision on who pays their bill.
Exactly. Our source for this is the actual High Court judgment itself from June 10th, 2025. It's pretty detailed, lays out all the judge's thinking.
So we're going to unpack the two main things the court looked at. The contractor trying to enforce an adjudicator's payment decision.
Right, the enforcement application.
And the homeowners pushing back, saying their own notice, their payless notice, was perfectly valid.
And along the way, we'll uncover some, well, pretty surprising facts, I think, and look at these construction law details that honestly could affect anyone taking on a big building project.
Okay, let's unpack this.
So let's set the scene. The players. We've got RBH Building Contractors Ltd. That's run by a Mr. Roger Huntley.
The contractor.
The contractor. And then Mr. and Mrs. James, the homeowners, the employers in this contract.
And their plan was pretty ambitious, wasn't it?
Oh, yeah. They bought this property in Ferndown, Saunton, North Devon back in 2019. The idea was knock it down, build this large luxury house.
Okay, and the initial agreement, how did that work?
Well, interestingly, it was an oral contract back in January 2022.
No written terms initially?
Not at the start, apparently. The deal was RBH gets £1,000 a week for supervision project management, plus another £10,000 a month for 18 months for the same thing, and then obviously reimbursed for subs and materials. But RBH also later claimed an extra fee for overheads and profits.
Ah, okay, so that became a point of dispute later, I imagine.
It certainly did. So work starts January 2022, but by April 2024, it grinds to a halt, still incomplete.
And the Jameses had paid quite a bit by then.
Over £1.3 million. $1,310,039.04 to be precise.
But RBH felt they were owed more.
Much more. November 18th, 2024, they send a payment application asking for an additional $663,016
Woof. And it came with a detailed spreadsheet, you said?
Yeah, a big Excel file laying out their claim.
So the Jameses had to respond to that.
And they did pretty quickly, actually. November 27th, just 9 days later, they send a letter. This is their notice of intention to withhold payment, what we often call a payless notice.
Yeah, their intention.
To pay zero.
Okay, bold move. Did
Right.
they explain why?
Oh, yes. The letter was quite specific. They listed reasons like insufficient evidence for big subcontractor payments. Figures like $94K for one, nearly $20K for scaffolding, thousands for tiles, timber.
So challenging the proof for those costs.
Exactly. They also mentioned unpaid invoices they said weren't even due to RBH yet, like for roof access, a glass balustrade worth $45K.
Right.
And they flat out rejected RBH's claim for overheads and profit. That was nearly £78,000. Plus, a bonus tied to rental income they said wasn't due because the project was so delayed.
So they were challenging multiple parts of RBH's claim.
Absolutely. And crucially, if you add up all the specific things they disputed in that letter...
How much did it come to?
Over $1.2 million. $1,245,145.55.
Which is way more than the £663,000 RBH was asking for.
Precisely. So it clearly justified, on the face of it, their position of paying zero. And it's worth noting, at this stage, they had legal advice, but they weren't yet arguing that adjudication itself didn't apply to them.
Okay, so they sent the notice. What did RBH do?
They went straight for adjudication, served a notice of adjudication on December 6, 2024.
And this was the smash and grab attempts you mentioned.
Exactly. RBH's argument was basically, your payless notice isn't valid, therefore the full £663,000 is automatically due. Forget arguing about the details of the work for now.
Right, a procedural argument rather than getting into the weeds of the valuation.
Correct. And since there was no written contract defining the process, the statutory scheme for construction contracts would apply.
Unless an exception was found.
Exactly. An adjudicator, Mr. Robert Scheuer, was appointed. The Jameses weren't happy, complained about the timing near Christmas, but the process moved forward.
Okay, so the adjudication starts. But then the Jameses bring out their main defense.
This is where it gets really interesting. They argued to the adjudicator and later in court that they were residential occupiers.
Ah, the exception we mentioned. Section 106 of the Construction Act.
That's the one. The Housing Grants, Construction, and Regeneration Act, 1996. Section 106 says the whole statutory adjudication scheme doesn't apply to a construction contract with a residential occupier.
And the idea behind that is to protect sort of ordinary homeowners.
Exactly. People building or fixing their own home, not developers doing it as a business.
So how did the adjudicator react to that argument?
He wasn't convinced. He rejected their jurisdictional objection.
Why? What was his reasoning?
Partly because the planning application for the house had a box ticked for market housing, not self-build.
Okay.
And also, he felt that because they'd submitted a payless notice under the scheme's rules, they'd kind of admitted the scheme did apply to them. An implicit acceptance, perhaps.
I see. But the high court judge took a different view.
A much deeper dive, yes. The judge really focused on the core question for being a residential occupier. Do you occupy or intend to occupy the place as your home?
And when does that intention matter?
Crucially, it's your intention at the time you enter the contract. So back in January 2022 in this case, though the judge said you can look at later events to figure out what that original intention objectively was.
Okay, so what evidence did the Jameses have to show they intended to live there?
Quite a bit, actually. They had bought the land in 2019, planning to move to Devon. It was a long-term plan. They sold their house in Essex.
Right.
And they even reclaimed the 3% stamp duty surcharge you pay for second homes, arguing this was now their only home.
That seems pretty significant.
It does. Plus, they were literally living in a caravan on the site during the works, registered with a local GP on the electoral register there.
Physically present.
Mm-hmm. And the house design itself had personal touches. Mr. James is an Ironman competitor, apparently, and the design included a basement lap pool specifically for his training.
Tailored to them personally.
Exactly. Their architect also backed them up, saying his understanding was always that they planned to live there. Even some messages from Mrs. James's phone suggested friends thought it was their home, not a second home.
Okay. Sounds like a strong case for home. Did they mention the Airbnb plan?
They did. They admitted they planned to let it out for maybe 13 weeks a year through Airbnb, mostly to help pay back the financing. But they insisted it was still primarily intended as their main residence.
Okay, so that's their side. What evidence did RBH have suggesting it was more of a development property?
Well, RBH's boss, Mr. Huntley, said he was never explicitly told they planned to live there, and he always saw it as a development project.
That's perception.
Right. But the really big stuff RBH pointed to were these commercial development loans.
Oh, yes. The loans taken out by Mrs. James and a company linked to Mr. James.
Exactly. And these loan documents contained very explicit written statements, undertakings, essentially.
What did they say?
Things like, the charged property is not used as and will not be used as a dwelling by the borrower or a related person of the borrower.
Wow, that's direct.
And the loan will be used for business purposes. And Mrs. James herself personally declared, quote, neither myself, ourselves, or any of your family or close relatives nor your partners reside, nor have any intention to reside at the property.
That seems like, well, a direct contradiction to their residential occupier claim.
It absolutely does. On top of that, you had the planning document ticking market housing, not self-build. And other site documents, like health and safety notices, listed Mr. James' property company Trilogy as the client, not Mr. and Mrs. James personally.
So a real conflict of evidence there. How did the judge weigh those loan declarations? Did he see them as the final word?
No, and this is really interesting. He rejected RBH's argument that the loan declarations were determinative. He said, look, breaching a loan agreement is a civil matter between you and the lender. It's not the same as, say, unlawfully occupying a property in breach of planning rules, like in some other cases.
So lying on a loan form isn't the same legal category as breaking planning law.
In the context of deciding the specific statutory question, residential occupier status, no. The judge said the declarations were definitely part of the overall picture of their objective intent, but they weren't the whole picture. They didn't automatically disqualify them.
That's a subtle but crucial distinction.
It really is. It shows how judges have to carefully draw lines. What you say for one purpose, like getting a loan, doesn't automatically dictate your status under a completely different law, like the Construction Act. You've got to look at the specific legal test for that law.
So where did that leave the judge on the jurisdiction issue?
He concluded that the factual dispute about the James's real intention back when the contract started was just too complex and significant to decide quickly, summarily.
It needed a full trial.
Exactly. He said it needed oral evidence, cross-examination, the whole works. Similar to another case, Westfield's Construction v. Lewis. You couldn't just decide based on the documents.
So the outcome on RBH's enforcement application?
Dismissed. The judge found the Jameses had a real prospect of establishing they were residential occupiers, which meant the adjudicator likely had no jurisdiction to make the decision RBH was trying to enforce.
A big win for the Jameses on that front.
A very big win. It stopped the enforcement dead in its tracks, at least for now.
Okay, so RBH's attempt to enforce the adjudicator's decision is blocked because jurisdiction is seriously questionable.
Correct. But the judge didn't stop there. Everyone agreed there was still this lingering question. Okay, assuming the adjudicator did have jurisdiction for a moment, was that payless notice the Jameses sent actually valid?
Right, because that was the basis of RBH's whole smash-and-grab claim.
Yeah.
If the notice was valid, then RBH wasn't automatically owed the money anyway.
Exactly. So the judge agreed to rule definitively on the validity of the payless notice.
So let's get into that. What makes a payless notice valid under the law? Section 111, right?
Section 111, subsection 4. It basically says the notice has to specify two key things.
Which are?
1, the sum the payer genuinely considers is due. And importantly, that sum can be 0.
Okay, and the second thing?
The basis on which that 0, or whatever sum, is calculated, you have to explain why you think that's the amount due.
How strictly do courts interpret that requirement for the basis?
Well, the case law, like Advanced JVV and ISCA, says courts use objective construction. How would a reasonable recipient, knowing the background, understand the notice?
Not just how the person who got it actually read it.
No, it's objective, and courts tend to take a common-sense, practical view. They're apparently unimpressed by nice points of textual analysis, which is good to know.
So less about legal nitpicking, more about practical understanding.
Pretty much. The notice just needs to make it tolerably clear what is being held back and why. It needs to provide an adequate agenda for an adjudication, basically, outlining the areas of dispute. There's no strict rule it needs a specific title or must include a detailed mathematical calculation within the notice itself.
Okay, so how did RBH argue that James's notice failed that test?
They argued it wasn't clear enough. They said it didn't state what bits, if any, were accepted and didn't really show the basis for arriving at £2. They pointed out that if you just added up the few quantified bullet points, it only came to about £295,000 disputed, not the full £663,000 claimed.
So RBH wanted more detailed arithmetic in the notice itself.
Seemingly, yes. But the Jameses' lawyer came prepared. He presented what the judge called a helpful table.
What did the table show?
It mapped every single one of the 11 bullet points in the payless notice directly to specific line items and amounts in RBH's own detailed payment application spreadsheet.
Ah, so connecting the dots clearly.
Exactly. It showed that every point of dispute raised by the Jameses related to a specific part of RBH's claim.
And what about the total value? We said earlier the disputed items added up to over $1.2 million.
Yes, and the judge specifically noted that. He said, look, the total value disputed in this notice clearly and significantly exceeded the £663,016 at 16 being claimed by RBH.
So it was obvious why they were proposing to pay 0.
Absolutely obvious. The justification was right there in the scale of the dispute outlined.
So what was the judge's final verdict on the notice?
He sided completely with the Jameses. He declared their letter from November 27th, 2024 was a valid payless notice.
Why? What was his reasoning?
He said it clearly set that adequate agenda for an adjudication. It identified specific elements of RBH's claim that weren't accepted and gave brief reasons why. And crucially, he explicitly stated the notice did not need to set out an arithmetical calculation to be valid.
So the substance and clarity of the dispute mattered more than the maths within the notice.
Precisely. The key takeaway here, I think, for anyone drafting or receiving a payless notice, is that clarity about what is disputed and why is paramount. You don't necessarily need to provide a full reconciliation, just a clear basis for your position that allows the other side to understand the dispute, substance over form.
Right. And the implication of this finding.
Because the payless notice was valid, it meant that, based on the notice, no sums were actually due to RDH at that point.
So the adjudicator's decision saying sums were due
was, in the judge's view, wrongly decided on the substance. Even if he had jurisdiction, he got the payless notice point wrong.
Another win for the Jameses. So they won on jurisdiction and on the substance of the payless notice.
Double victory on the core issues.
Which brings us to the final, perhaps most painful part of this saga, the adjudicator's fees.
Ah, yes, the sting in the tail.
The adjudicator had ordered the Jameses to pay his fees about £9,600 plus VAT. Now, given the High Court found he probably had no jurisdiction, and he got the main point wrong, surely the judge could just cancel that fee order. Seems only fair.
You would absolutely think so, wouldn't you? It feels like common sense. If the whole decision is wrong, why should you pay the person who made it?
Exactly. But the law sees it differently.
Very differently, unfortunately. This is where it gets quite counterintuitive. The judge looked at a lot of case law, including a key Scottish case called Castle Inns, which English courts follow.
And what's the consistent legal position?
That a court generally has no power to interfere with an adjudicator's decision about their own fees.
No power. Even if the adjudicator was fundamentally wrong about the case or didn't even have the right to hear it?
Generally, no. It seems incredibly harsh, but there are established legal reasons behind it.
Okay, walk us through those reasons. Why are the fees untouchable?
Well, firstly, there's usually no contractual mechanism or specific rule within the adjudication process itself that allows you to challenge or appeal just the fee decision.
The rules didn't provide for it.
Right. Secondly, the courts see the power to challenge an adjudicator's decision as applying only to the underlying dispute, the argument about the construction work or the payment. The decision about who pays the adjudicator's fees is considered ancillary to that main dispute.
So it's treated as a separate secondary issue that the court challenge doesn't cover.
That's the thinking. Thirdly, there's this idea of commercial necessity or lack thereof. While it might seem unjust, the legal system sort of accepts that parties in any dispute resolution process might end up bearing costs they can't recover. It's seen as a risk of the process.
A bit of a tough luck aspect.
You could say that. And finally, there's a practical difficulty. Adjudication is meant to be quick, rough, and ready sometimes. Decisions can be hasty. Court proceedings are much more thorough, often with more evidence and different arguments.
So it's hard for a judge, after a detailed court hearing, to fairly second-guess how an adjudicator decided to allocate their fees based on a much quicker, different process that happened earlier.
Exactly. How can the court accurately judge, for instance, how much time the adjudicator spent dealing with a specific argument that maybe wasn't even run in court or was run differently? Remember, the Joneses actually lost a preliminary point during the adjudication itself, which would have formed part of the adjudicator's work and costs. It's just too difficult to unravel fairly.
Did the Jameses' lawyer try to argue against this?
Oh, absolutely. He tried to distinguish the previous cases, suggested a Supreme Court case about recovering overpayments, aspect contracts, should apply by analogy to fees, even argued for an implied term allowing fee recovery.
The judge wasn't buying it.
No. He systematically went through the arguments and rejected them, sticking firmly to the established precedent from Castle Inns and other cases. He concluded he was not persuaded he had the power to change the fee order.
So the final outcome on fees.
Mr. and Mrs. James, despite winning on the big points about enforcement and the payless notice, are still legally required to pay the adjudicator's fees of nearly £10,000 plus VAT.
Wow, that really is a hard pill to swallow after winning the main fight.
It truly highlights a potential unfairness baked into the system.
Okay, let's quickly recap the outcomes of this really quite complex deep dive.
Sure. First, RBH's application to enforce the adjudicator's payment decision. Dismissed. Because the Jameses have a real chance of proving they were residential occupiers, meaning the adjudicator probably didn't have jurisdiction.
Second, the Jameses' payless notice. Valid. The judge ruled it met the legal requirements, meaning the adjudicator got the substance wrong and RBH wasn't owed that sum based on the notice.
And third, the adjudicator's fees. The court could not change that order, so the Jameses, despite winning points 1 and 2, still have to pay the adjudicator's bill.
So what does this all mean for you listening? This case really peels back the layers of construction law, especially if you're a homeowner undertaking a big project.
Definitely. It screams about the importance of documenting everything, especially intentions, even if you start with a verbal agreement. And it shows how critical getting those legal notices, like payless notices, technically right is, though practicality wins over pedantry, thankfully.
And it really throws into sharp relief this tension, doesn't it, between the fast, sometimes rough justice of adjudication designed for speed
and the much more thorough, detailed, but slower justice of the High Court. The two systems don't always mesh perfectly, especially as we saw when it comes to who picks up the tab at the end.
It does seem like a real balancing act.
It is, and it leaves us with a thought, doesn't it? What does this kind of mixed result, where you can win on the core legal points but still be left out of pocket on costs like adjudicator fees? Tell us about the balance we strike between efficiency and absolute fairness in legal processes.
That's a great question. And maybe more practically, if you were about to start a major home build, after hearing about the James's roller coaster ride, what's the one piece of advice you'd absolutely take to heart to protect yourself? Something to think about.